Hello, everyone, and good morning or afternoon. We'll give folks another minute or two to join before we dive in. All right. I think we've probably reached a critical mass, and we have a lot of exciting content to cover today, so let's get started. Thank you for joining our webinar on managing privacy risk in a complex U.S. regulatory environment with Michael Hahn from the IAB and Daniel Goldberg from Frankfurt Kurnit. And Jeff Wheeler from Didomi is unfortunately out sick today, but a huge thank you to Jenn Buckingham from Didomi's product marketing team for stepping in at the very last minute to cover Jeff's portion of the presentation. Jenn is going to do her best to answer any of your questions about the Didomi platform and how it can support some of the privacy challenges that Michael and Daniel talk about today. But please have patience with her because she is jumping in at the very last minute and didn't really have any time to prepare for this. So she may have to, on occasion, tell you that she'll get back to you on certain questions. Before I turn the mic over to our other panelists, I want to mention just a couple of housekeeping items. We are recording today's session, and the recording will be made available on demand later this week. If you have registered, which I think everyone here has, then you should receive an email once the recording is available. We also have a questions tab available, so please feel free to drop your questions there, and we'll aim to answer as many of those as time allows, either during the presentation, if the timing is appropriate, or at the end of the presentation. So I think that covers all housekeeping items. So let's dive into introductions. I'm Julie Rubash. I'm the General Counsel and Chief Privacy Officer for Sourcepoint by Didomi. I handle the internal legal and privacy matters for our company, but I also work closely with our teams to ensure that the products and support we provide to our clients are up to date with evolving privacy requirements and industry standards, such as those we'll be talking about today. And I'll let my co-panelists introduce themselves. Daniel?
Thanks, Julie. Hi, everybody. I'm Daniel Goldberg. I chair the data strategy group at the law firm Frankfurt, Kurnit, Klein, and Selz. And I've known Michael and Julie for a very long time. So I'm really excited to be talking about this with both of you. And Jenn, happy to have you here as well. In my role, I counsel clients on all issues relating to privacy and data monetization issues, and ad tech is a very large portion of that, and the opt-outs and all of that, which we're going to be talking about today. And of course, dealing with response to regulatory enforcement action and litigation claims. And so I will pass the baton here to Michael, but looking very forward to this conversation.
Well, thank you, Daniel, and thank you to the Sourcepoint and Didomi team for inviting me to join this discussion. I'm Michael Hahn. I'm the Executive Vice President and General Counsel of the IAB. I help to lead our legal affairs and public policy efforts with a deep focus on privacy. And I'd like to think on our best days, we're trying to up-level privacy for the entire digital ad ecosystem and spend a good deal of time thinking about some of our industry frameworks and technical signals, and also engaging with regulators on these issues.
Jenn?
Happy to jump in. Great to be here with you all today. Really excited for the conversations that we will be having. So thank you so much for joining. My name is Jenn Buckingham. I am a product marketing manager at Didomi, and really work very closely with our product team to understand what they're building, why we're building it, and how it can bring value to our customers. So yeah, thank you. Thanks so much for joining today. I'm happy to take this slide, kind of give us a little introduction to Didomi for those of us who might be new today. So just a little bit of background. We operate in about 27 countries, support over 50 languages, and also cover over 2% of global internet traffic with 60 billion monthly page views. We also have a 95% customer retention rate, and every quarter we collect consent on more than 2 billion devices. So a little bit of a brag sheet, but just kind of wanted to provide a little bit of context on Didomi for us today. So I'll give it back over to Julie.
Thank you, Jen. So I'll jump into the agenda. As far as the agenda goes, Daniel is going to start with a general update of recent U.S. state enforcement trends. Michael is then going to double click on some particularly notable enforcement out of California, specifically the Honda Healthline and the latest Tractor Supply Company cases. And talk about what went wrong in those cases and implications for use of the IAB frameworks. Daniel is then going to pick it up again with some practical takeaways and best practices gleaned from recent enforcement. And Jenn will demonstrate the Didomi and Sourcepoint tools and how they can help ease the overhead of using the IAB frameworks and complying with the constantly evolving privacy laws. And then finally, we'll end the session with a Q&A, as I said, but so you can feel free to drop your questions into the chat throughout the presentation, and we'll try to get to them when we can. All right. With that, Daniel, do you want to start?
Yeah, sounds great. So one of my favorite things about this area is that we can prepare all the slides we want, and then immediately you find out, like, oh, there's a new enforcement action. So we had to scramble to add one, and Michael will be talking about that soon. But you guys are among the first for us to really talk about this. I don't think we've even talked internally about Tractor Supply Co. So there'll be some interesting discussion here. What's important to note is that enforcement is up. What we see, and this is why I have the image here, and actually this comes from California's office, is that there's a lot of enforcement, but you only have the tip of the iceberg here, right? Of what we're starting to see is like what's on top is what's public, but below that iceberg, there's a lot of stuff going on that is not public that we're dealing with letters that companies are getting, issues that companies are responding to, of course, all the litigation that we're seeing. But point being is that there's a lot of investigation going on. This is a recent statistic from the CPPA where just within the last 2 years, essentially, there's been over 8,000 complaints to the CPPA. And a lot of the enforcement that we're seeing actually comes from a complaint. And in this recent Tractor Supply Co. Settlement that we just saw, it talks about that this actually did come directly from a complaint that was made by a consumer. So that's a really interesting takeaway. You know, do not, if you get a complaint directly, don't disregard that. Who is enforcing? We've seen over the last several years a lot of enforcement by the FTC, although with the new administration, we've seen less, or we've seen focuses on different types of enforcement. But really, where we all talk about in the privacy sphere is enforcement by the state attorney generals, by California, by Texas. We've seen a lot of that in the last several years. Again, we just saw a new one from California yesterday. And then, of course, there is the Associated California Privacy Protection Agency, which actually was responsible for that enforcement yesterday. And then there's a lot of stuff going on in the litigation sphere, which I would guess many of you on this call are familiar with the wiretapping claims. We've seen claims now relating to Shine the Light. A lot of it relates to deployment of tracking technologies without consent, allegedly. And so, again, that's a big area that we're all looking at about how does that actually correspond with the obligations that we have under comprehensive state privacy laws. So what's really interesting is that in April, right, state regulators announced that they were forming a bipartisan consortium to collaborate on privacy issues. And this is an area that we've seen quite a bit with various state regulators looking to each other on privacy enforcement. And I know Michael can probably speak more to some of his, what he's seen in his area, but that the regulators do look at each other, what they're doing, and that informs a lot of their decision making in the actions that they're bringing. And so what we've actually seen is that joint actions have already begun, right? And so this is pretty recent. This is from last month, where California announced a joint investigative sweep of opt-outs of sales of information. And of course, that's a big discussion point we're going to be talking about today, opt-outs and configuration and all that stuff. So again, regulators are looking to each other. This is a post that I put together. We have a blog, the Technology Law blog. I think it's a really interesting post where one of the things that we've seen is, not in California, but in other states, we have seen agencies actually partnering with law firms to bring enforcement actions. And this can be on a contingency basis. And what's interesting is that some of these are brought not necessarily under a specific privacy law, but more under general consumer protection rights. And so this is all important when we think about the bigger issue of like, how do we address compliance across the ecosystem? One thing that we've seen a lot of lawyers counseling clients is like, oh, well, why don't you look at the laws that are in place, and that which are the states that are most likely to enforce and have the largest enforcement bodies. And that's been a really good way to look at it. Okay, so California and Texas, but now suddenly states that you didn't really associate with having those types of enforcement mechanisms, Utah, Nebraska, Michigan, all of a sudden it's like, wow, there could be cases brought by these states. So the point is that it's really important to be thinking holistically across the states and not saying, okay, well, we're not going to address specific states because we don't think that there's obligations there. Key areas.
Before you move on to key areas, I have a quick question. In your experience, and I'm not asking you to have like a crystal ball, but when there's these investigative sweeps from the regulators, how does that normally work? Like, what should companies be anticipating as far as whether they're a target, and how the investigative sweep is going to be looking for potential people to investigate?
Yeah. So what's interesting is that investigative sweeps can happen for various reasons, but usually what I've seen happen there, at least from what I've heard, is that a regulator gets interested in an area. Maybe it's relating to cars or something like that, like vehicles. That's one way that this happens. And so they send out a letter to various vehicle manufacturers to say, hey, like, we want to understand what your data practices are. Another might be that a regulator walks in to a large retail store and sees some issues around their loyalty program and goes, oh, wow, like, this is a concern. So now we're going to send letters to everybody who has loyalty programs in this area. So what I've heard from regulators, right, is that they think of themselves, and it's true, like, they're also consumers. So a lot of what I think impacts their decisions of what actions to bring is based on them being consumers, which is actually a really interesting thing about Tractor Supply Company. And we can talk about this in a bit. But that what I thought was interesting is that this is a company that you would not think to be traditionally targeted by regulators, right?
Maybe one of the regulators has a tractor.
Exactly. Maybe they do. Right? It's a non-California company. And I mean, they have offices in California and everything, and they have stuff here, but it's really focused on an area that it's like, well, really a tractor-based, company. And so what I think is an important takeaway there is, again, like in this one, it was also the investigation started from what I understand about a complaint. So to my point before, like, do not underestimate if you get a complaint from a consumer or data subject requests that you just don't address. Those seem to be like the highest areas that lead to an investigation or a sweep. And then once you're subject to a sweep, my thought is, and we can talk more about it, right, is that you want to be as forthcoming as possible and try to address any deficiencies as quickly as possible. A lot of these sweeps are still based on laws that have some type of a cure period. So you might get a letter, from example, from like Oregon or something that says you don't have specific disclosures around the right to request the list of third parties, or something like that. And so that'd be something that seems like a pretty easy thing to remedy and respond back to them and say, okay, well, we've addressed this concern. And a lot of times, in my experience, these go away. And where they amplify is where you don't immediately address it, or where it's a situation where it just can't be addressed as quickly.
I also wonder with Tractor Supply, we'll talk about the facts of that later, but this was also the first instance where I believe in sometime during the summer where Tractor Supply did not respond to the CPPA subpoena, and they went into court for the first time and enforced the subpoena. So, bad tactical moves sometimes also result in terrible outcomes.
I 100% agree with you, and we'll talk about that in a bit, but I definitely want to chat with you more about that, because I think that's a huge point that you just made, perhaps the most important takeaway from that case. So in terms of key areas, these are, when you kind of boil down all the cases we've seen, and again, Michael's going to dig in more to the specific cases. The one that we just keep seeing, right, is around sales, shares, and targeted advertising. And we have the list here of some of the cases, right, from California, but I would be adding Tractor Supply Co. onto this as well. Issues with the opt-out mechanism. It doesn't work. GPC fails. It improperly requires verification. The way that the form is set out, Tractor Supply talks a lot about, basically shows a form. And again, we can talk more about that around implementation. Issues potentially around dark patterns, improper process for authorized agents. There's the issue of purpose limitation that I'm sure Michael will talk more about when we think about what happened with Healthline. And then contracts has been one that we've seen come up a number of times now, about not having the statutorily required language in your contracts. Like, that is something that they're looking at very, very closely. Other key areas around data brokers, failure to register, collection of sale and sensitive location data without notice or consent, issue around children and minors. This continues to be one both at the state and at the federal level. This seems to be one of the areas that the FTC has continued to focus on under Ferguson. And so again, like a really, really important thing, if the company deals, if you're in gaming or any type of area where there may be minors, and it's not just under 13 to 15 or teens. And we see a number of states now that even have restrictions, generally even at higher numbers for, all minors under the age of 18, which is really difficult to comply. That's a huge area right now. And then, as I mentioned before, requirements around the disclosures, around obligations for disclosing specific third parties. And we've seen inquiries around that specifically. And then the last one, which we'll talk about, is also now reference to job applicant data, which just came up in the Tractor Supply Co. So Michael, you're up now. We can talk more about Honda. What's going on there?
All right. So Honda was in many ways an ordinary and extraordinary action at the same time by the CPPA. So let's start with, what was ordinary about it? Well, this is one of the milieu of cases where the company could not get the configuration done correctly for their digital properties. So what the CPPA said was that they had not properly designed the opt-out process, the consent process. The website banner had lacked symmetry of choice for making privacy elections. It required ID verification for opt-outs and unnecessarily asked for certain personal information that did not need to be processed upon opt-out. And, of course, they run the tests and they say, okay, I've opted out through their investigators, and then let's see if cookies and tags are still firing, and then they still fire. So in many ways, this is a repeated kind of story that we hear in each of the enforcement actions, and what makes the Honda action fairly ordinary. But what I thought made it really an interesting case was related to the contract requirements. So this was one of the first major cases where the CPPA said, we are going to enforce under Section 100D, which in the CCPA requires that you have a contract for the sales of personal information to third parties that contains around a half a dozen different privacy protective provisions, and also requires adequate purpose specification as it relates to what the receiving party is going to be using the data for. That's consistent with the CCPA. And when the CPPA asked Honda for its contracts, it was unable to produce its ad tech contracts. So what I'm about to articulate is not spelled in the complaint, but is based on my general understanding about practices as they're leveraged in the digital ad industry. So why wouldn't Honda produce its contracts? Why didn't it have the contracts to give? Well, because it never entered into any of those contracts. Well, how is that possible? That's possible because Honda is doing what many, many, many advertisers do, which is ride on their ad agency's contracts with the ad tech providers. And the takeaway from Honda is that the current structure, the way the ad agency contracts are set up for clients to ride on them, do not comply with Section 100D because it does not establish direct privity as it relates to those necessary contractual terms unless you amend that in a way that would be very tough for the ad agency to make work. It would require them to name all of their clients as third-party beneficiaries, and it would require them to disclose to their clients the ad tech contracts. This is not something that happens for a number of business reasons. So when we took a look at this fact pattern, we said, this would be a perfect use case for the IAB MSPA. And for those who don't know, the MSPA is an industry compliance framework. It's really an industry contract that serves as a springing contract that comes into place that creates a common set of privacy terms amongst the signatories. So there are 1,400 signatories to the MSPA right now. And when an advertiser or publisher declares it to be an MSPA covered transaction using a technical signal called the GPP, it means the inventory can only get sent to another signatory. And then everyone's agreeing to these same privacy terms. So had Honda been a signatory, and had the ad agency been a signatory, if they were in the data flow, sometimes yes, sometimes no, but at least required that their ad tech counterparties had been signatories, Honda would have had the privity of contract with them, and the problem would have been in many ways ameliorated. I would add the second thing that could have been a game changer for Honda too, is that if it had deployed the GPP. So if the GPP is this technical specification that sends signals that says the consumer, we gave the consumer notice, have they opted out of sale or share and targeted advertising, have they opted in for sensitive personal information and those sorts of things. But if you're an MSPA signatory using GPP, when the consumer opts out, the ad tech partners automatically become service providers. So if you have an accidental misconfiguration issue, the data would be sent to service providers who'd be limited in the ways that they could use it. And it would have been belt and suspenders. Now, that wouldn't have dealt with all the dark pattern issues and a number of the UI interfaces, but it does give an opportunity for a backup.
And just to chime in, for anyone who may not be all that familiar with the GPP and all of these specifications that Michael's talking about, it may sound like a lot and very complicated and something that's going to require a lot of work from your engineers, etc. But that's why companies like Didomi exist. We can absolutely help you through all of that. It's something that the CMP is built to support. So just a little plug for Didomi, and Jenn will talk about that later in the presentation as well.
Yeah,
and I also,
go ahead, Jenn.
Yeah, I just wanted to add, Michael, what you said, I feel like cannot be overstated. Like, I would say perhaps the number one issue I see in the ad tech ecosystem, I work with a ton of brands and agencies, is that so much stuff is just done still based on insertion orders, and that there's just no terms around data. And I bring this up all the time. And one of the issues that I still hear is, well, the publishers don't require it, or the ad tech vendors don't require it. And so my plug for the MSPA is that I think it really benefits the whole ecosystem in so many ways. And what IB has done has really been tremendously helpful, because it allows these things to potentially go forward, right, with a level of compliance where you feel much better. Now, there's other cases we'll talk about that you can't just be like, oh, you'll agree with the MSPA and that's enough. But I think to have these terms set in really makes everything easier for compliance across the ecosystem.
And to add to that, and what Julie was saying, one of the important things that a privacy vendor does is actually they're the ones who write the string on your behalf. So when we talk about things like the GPP and companies like Didomi supporting it, they're the ones who are operating on your digital property. And when the consumer opts out and you're an MSPA signatory, that would literally be encoded into a string that Didomi would write on your behalf and send it to the partner who would be contractually obligated to read and comply with it. So hopefully I didn't take away some of Jenn's presentation there, but I think that is an important point. Well, let's go to Healthline, right? So Healthline, from my point of view, is probably the most seminal enforcement action for a number of reasons since probably Sephora. To me, they're the two largest bookends on enforcement in the United States. And Healthline is significant for a number of reasons. I mean, of course, just like all the other cases, right, it all begins with misconfiguration. They were facilitating targeted advertising even after the consumers opted out. I believe they said in the complaint, 118 cookies dropped and 82 pixels fired even after opt-out. So that's the ordinary. What was extraordinary about it? Well, first, this is the first enforcement action that involved data minimization in the United States. And it's something that I've thought for at least 18 months now, that if I had to say what is the biggest impact that regulation is going to have in digital advertising, it's going to come from data minimization. So just a little bit of a brief reset, right? Data minimization is the information that you collect and process needs to be reasonably necessary and proportionate to the disclosed purpose, or at least if you're not in Maryland, and that in states like California and Colorado, in the regulations, there's an overlay that it needs to be consistent with the consumer's reasonable expectations. And of course, you're wondering, like, what does it mean to be consistent with the consumer's reasonable expectations? We don't exactly know, but that's what makes this seminal, because this is the first time that they're saying something is unreasonable. And it's the beginning of the equivalent of developing case law. So in the case of Healthline, the title to the articles, which often indicated a health issue in particular, was getting passed into the bid request and sent to other parties downstream. And so what was interesting is that they weren't saying that it violated another provision in the law. They said it was the data minimization provision, that it was inconsistent with a consumer's reasonable expectations that they would be reviewing a health article, and that the title of that article would get passed on to another party. And it was found to be unlawful on that basis. So this is the beginning. This is the first case of something that's been found to be unreasonable. And it is an area that I think is going to continue to grow and mature. And we're going to definitely need to pay very careful attention to over the next 2 years.
And Michael, I just want to add, what I think is interesting is the question about, like, was it inherently unlawful, or is there a way to do it? It just requires consent, right? which, by the way, would bring it in line with a lot of other states that we see. Because if you fail that reasonable expectation test, then you do need to get opt-in consent for that. Although there still is an argument that even that could be unlawful. So you're right, it has such interesting implications and affects an area that, if you're engaged, if you're using ad tech in an area where there's anything tangentially relating to health, it may completely impact your ability to use advertising technology in that area.
Yeah, that is a fantastic point, right? Which is, can consent remedy something? Well, it's really more along the lines of, does consent make it consistent with the consumer's reasonable expectations?
Exactly.
Or more prominent notices, more clear notices, kind of to set those expectations.
They seem to downplay that as an opportunity set in the case in certain places. It struck me that it would be pretty hard to do it through notice, but to get some affirmative consent would probably put you in a much better position. One could make the case that effectively it becomes a ban if you can't get consent. So interesting times to sort through all the data minimization issues, and really now what are three evolving different standards that exist in the United States between Maryland on one end, the states that have just this reasonably necessary proportion to a disclosed purpose at the other end of the spectrum, and California and Colorado in the middle, who bring in this consistent, this consumer reasonable expectation standard into the mix. But then I think what really makes the case fascinating is that Healthline was an IAB MSPA signatory, and there was this incredible focus on both the contracts and technical signals. And I'm going to read a quote from the case, which I thought was really salient and powerful in terms of how the regulators were thinking about it. So they say in the complaint, businesses' over-reliance on vendors, outdated boilerplate contracts, and deprecated privacy signals can result in violations of law leading to substantial penalties. These are things that are happening all the time in the digital ad industry. So in many ways, what Healthline did, there are a number of parties that are doing the very same thing, and this becomes a shot across the bow. So let's start in and talk about the contracting issue first. So Healthline was, in fact, an MSPA signatory, and while they didn't mention the MSPA specifically in the complaint, they acknowledged that they had signed this industry this industry contract that provided the terms that were necessary for 100D and provided for purpose specification. And what they said was, well, the problem was that Healthline did not send the covered transactions always to other signatories, which was a requirement in the MSPA. One MSPA signatory can only send it to another MSPA signatory who's agreed to comply with the terms. So the first thing that was notable is that the Attorney General's office didn't go ahead and say, let me review the MSPA for a determination of the adequacy of the terms or the purpose specifications. I think the implicit assumption was that they must have been good with it, because what they focused on were all of the contracts that Healthline entered into with non-signatories to the MSPA. And in those contracts with non-signatories, they found it significantly lacking in the requisite detail in a couple of respects. I think the first thing is that there was a whole host of, I'll call it typical conclusory language that we see over and over again. The limitation on data use was for internal business purposes, and that kind of language, which really does not cut it for purpose specification, right? In the MSPA, we list a whole host of digital advertising activities that have robust definitions for third-party segment creation, first-party advertising, frequency capping, target advertising, and so on, right? So there's details, and you can only use the data for digital advertising activities. And then, you contrast that with a contract that just says, oh, they could use it for an internal business purpose, or, some, sentence that's a throwaway like that. So there's, half a dozen different versions of those examples that were given in the complaint that were found to be insufficient. One of the things that I thought was critical was that when you look at the settlement agreement between Healthline and the Attorney General's office, the remedy essentially was you need to use the MSPA properly. In other words, they got to use it in a manner that doesn't result in a breach of the agreement. They had to, in the order, they were required to, as part of their compliance program, demonstrate that they were downloading the list of signatories if they were going to use the framework, and that they were going to send that inventory to them and send those signals to them. So that becomes a really important point about, I think the strength of the MSPA and also the deficiency of, I'll call it, some of the poor contracting processes that sometimes exist in the industry. On the next issue, which is privacy signaling. Again, this becomes another seminal issue. I have not heard a regulator in an enforcement action before focused on privacy signals, but this became a critical issue. So originally, the IAB Tech Lab had put out a technical specification when CCPA was originally enacted that was called the US privacy string. And it basically encoded consumers' opt-outs that tied to the original version of CCPA before CPRA even amended it. That was subsequently deprecated and replaced with the IAB Tech Lab's GPP, Global Privacy Protocol, that is basically a long concatenated string that has different sections for each state, as well as a special section reserved for the MSPA and those who take a national approach. Well, Healthline was sending the old US privacy string that had been deprecated. And they're not the only ones out there sending that. If you looked at traffic today, you'd probably see a healthy number of folks still using US privacy string. So the office took great umbrage with that. The second thing they took umbrage with was the notion that there was nothing in their contracts that tied the string to the partner taking any specific action in compliance with the law. So one of the things on the flip side that we do in the MSPA is we have a technical signals implementation guide that says when you get certain variables in the string, a 1, a 2 in particular slots, this is what the ad tech partners need to turn on and off when that happens. And that becomes embedded in the contract. So there was nothing like that in any of these contracts. And so the consequence of using that deprecated string, the failure to integrate the components of what behaviors were expected when the string is being used, meant that they could not get an exculpation from liability under 135G. So not expecting anyone to remember, what does 135G say? But this is very important for publishers and advertisers to understand. When you pass an opt-out to a partner in the digital ad ecosystem and they ingest it, right? You're hoping that they do the right thing once they've ingested the signal. You're provided with, under 135G, an insulation from liability unless you know or reasonably should know that they're doing something improper after you've passed an opt-out signal to them. What the Healthline complaint says is that Healthline does not benefit from an exculpation from liability because it didn't do it right, because it used a deprecated string, because it didn't do the contracts right in integrating behavioral changes when their partners receive the string. They don't get the benefit of that exculpation, which means they can be on the hook for what their partners do improperly and basically assume that liability. What a big risk. That's entirely unnecessary. So those are a couple of the big picture issues that I think come out of this important case.
Michael, this might actually be a great time, and you sort of answered the question a little bit, but to dive in deeper, we have a question from the audience. Please discuss how IAB Tech's GPP and MSPA with its privacy string meets the requirements of CCPA 1798.140V to make the ad tech resource that receives a website's user data to be a service provider so that the transfer of the data is not a sale. So I think that's along the lines of what you were talking about, but anything to be more specific about that switch that flips between a service provider and a third party in the event of an opt-out?
Yeah, I mean, so you know, if you think of the MSPA as kind of having two pathways, right? One of the things that it's doing is providing for the privity of contract throughout the digital ad ecosystem when the consumer does not opt out that's required under 100D. So that is a lot of what we're talking about in Healthline. One of the other functions of the MSPA is that when the consumer opts out, the companies downstream become service providers to the business or the controller, depending on what state you're in. And what we do is we have very limited data uses that the service provider can undertake. So you can't engage, obviously, in cross-context behavioral advertising. That is something that a service provider cannot do in California. But many publishers would say, well, I'd like to be able to deliver a contextual ad in that instance, right? But when you're using programmatic advertising, even to put out for bid a contextual ad, it requires the disclosure of the IP address, which would be a sale. But if everyone downstream becomes a processor to the controller or the business, then you're able to allow them for that limited purpose of being able to bid on the ad to and deliver onto the ad, but they can't take the data and use it for any other purpose. The other thing that you'd be permitted to do is engage in measurement and frequency capping, right? So you're able to do these basic things and still have some revenue recovery. So the question is like, well, does this work? You know, do the regulators accept this? I mean, very fair question. I mean, I think it does work because it does follow the letter of the law, right? Like those companies downstream do become service providers. They are limited in what they can do with the data and only using it on behalf of the publisher. Now, regulators will never say we endorse a particular solution or give, you know, a pre-green light or that sort of thing. But what I can say is that I've spent the last 5 years educating regulators on exactly what the MSPA does, exactly what the GPP does. I've met with many of them multiple times. Anytime there's an amendment to the MSPA, I also send that around. I continue to update them and have discussions and answer questions. So I think that comfort is about as much as one could get in the United States, at least.
And also, I think the Healthline case gives some comfort there as well, because the issue wasn't that they were using the MSPA. The issue was that they were using it incorrectly and not putting putting the right contracts in place by using the MSPA correctly. So I think that it would have been a very different decision if they had thought that the entire structure didn't work.
And I think maybe this is, Julie, a good segue to talk about the importance of vendor tool solution too, because these cases also talk about how the way that some of these mechanisms were on the websites did not allow the signals either to be properly passed or was requesting too much information, required verification, you know, and as I mentioned before. And so what we keep seeing, and especially, and I think we're going to jump to Tractor Co., is the same issues keep popping up over and over again, where the implementation is a really big part. And that a lot of times companies think that they've checked the boxes by hiring a vendor. Oh, this is the vendor everybody uses. We've implemented it. Oh, we signed the MSPA. We're good. We don't have to have anything in our contracts. And like, if there's one takeaway, it's that I don't think privacy is set it and forget it. You have to be looking at this on a regular basis. You have to be auditing your data flows. Tractor Code talks about the responsibility for updating your privacy policy on an annual basis, and they also have audit requirements to say you have to be looking at your data flows of the trackers. I think it was quarterly. So again, I mean, Julie, I think you could talk more about what your tools do, but like how that's such an important thing we see over and over again.
Yeah, and I think Jenn will be talking about this later in the presentation, and Jenn, you can feel free to chime in as well. But I think, yeah, you're absolutely right. There's two things. One, that privacy isn't, the same for everyone. So you can't just take an off the shelf solution, plug it in, and expect it to work perfectly for you. It's really about what your specific data flows are, who your vendors are, how you're using the data, and you need to make sure that the way that you configure the tool is reflecting all of that, and the disclosures you make, of course. And then the other thing is all of this changes on a constant basis. Your technology changes, your third party's technology changes, the laws change. So like Daniel said, it's not, you can't just put it up and move on to the next thing. It has to be something you're constantly monitoring, constantly making sure it's working as intended and as you're describing, and that you're making adjustments as all of these things change.
All right, well, let's move to the latest and greatest, which is Tractor Supply Company. So I think in many ways, the Tractor Supply case was, I think, pretty ordinary in just a whole number of respects, other than the fact that it was a tractor supply company. And, that's perhaps a new angle on it. And also what I'll call the factual context that probably existed post-subpoena. But the underlying facts were another case of a misconfiguration on Tractor Supply's digital property. So there was a web form that would get filled out for purposes of effectuating CCPA privacy rights. And, lo and behold, the ad tech stack, continued to fire, and pixels and tags and targeted advertising, or at least aspects of targeted advertising as we know it, continued. And so in that respect, it was somewhat ordinary.
I would like,
other aspect
Michael,
is
just some quick thoughts about that. I actually think this is something they didn't dive into it, but from what I'm hearing with regulators, I do think we're seeing something bigger coming on this area too, where what we have seen from vendor implementation is where basically there's two different ways to implement opt-outs. There's the opt-out through the web form, which a lot of vendors have basically bundled into their technology platform to be the same way that you do deletion requests, access requests, correction requests. And I think maybe it was in Honda where they talked about unbundling that. That's number one. Mm-hmm. And then there's the opt-out that we see that is around cookies. Oh, you can turn off cookies. Click here to turn off advertising cookies. By the way, this also opts you out of sales. And I've been talking with regulators a lot about this recently. And their expectation is that there really needs to be a single pop-up opt-out that effectuates everything. And so I'm just saying that this, to me, I thought was kind of a precursor. I actually just wrote a little bit of a blog on this, so it's on my technology law blog. Check it out. But that's where I think we're going. I think we're going to see a single pop-up that should say, by clicking submit, you opt out of trackers. By the way, if you also want to opt out of the CRM data, put in your email address and phone number here, and we'll opt you out, where we identify you in the back end. That I think is really, really important. So I don't want to downplay that as an important takeaway of this.
Yeah, I mean, that is a great point. I mean, one of the things that you hear over and over again from behind the scenes in some of the investigations is they're always counting the number of clicks and steps that it takes to effectuate the rights. And also, are you making it not unnecessarily complex and confusing? And so that does sound like you're on the track towards the direction they're going in the conversations that you're having. They also failed fundamentally in a number of other areas, right? Tractor Supply didn't process the opt-out preference signal, right? So that has been a frequent area of focus, I believe, including in the multi-state investigation. They've been looking for folks who don't satisfy that. Also, Tractor Supply did not have all the contracts in place with ad tech partners that satisfies the requirements of 100 date. So that also was a failure as well. And then, of course, that all led to, problems with their notice, right? Like if you're not effectuating things, your notices aren't correct, right? And it just goes downhill from there. So in many ways, I think that the outcome of, the substantive violations of Tractor Supply are sort of, added proof points to existing violations. But some of what is, I think, most interesting was how Tractor Supply responded to the CID. I wonder whether it would have ended up where it ended up had it behaved differently. Now, we don't know all of the insights about what went on behind the scenes, but if you're in the position of having the CPPA enforce the subpoena against you, you're doing it wrong. And so that was a position, but yeah, had some insight on that, Daniel.
So this is it. And I want to make sure, Jen, we don't have that much time. So I want Jen to be able to have a chance to talk. And we have a bunch of slides in a second. I'm just going to, Julie, I think we can pass through the next few slides for me. But what I was going to say is that this fine amount of 1.35 is so much substantially higher than the fines that we saw for Honda and Todd Snyder, which were only 5 months ago. Mm-hmm. And when you look at the allegations, like what you were saying, this is a Tractor Supply company, and these are pretty basic allegations. I do still think there would have been a penalty here, but I think it would have looked a lot more similar to what we've seen with the other ones. 1.35 is really high. It's among one of the highest. So my two takeaways are, one, we're seeing that the fines are going up. And I'm seeing this also on the California Attorney General's side too. So as we see more fines happening, don't expect that you go, oh, they only got fined $200,000 previously. They're going to be going higher and higher, right? Because California privacy law has been around longer. And the second thing is that the way you react to an investigation and the repertoire that you have makes a huge difference. I know that there was a quote recently from one of the Texas regulators who mentioned this, that said when a company responds, in a way that they're willing to work with us, that directly impacts the settlement negotiations. And the fact that the way this played out, and I do not have insight to the way that this played out specifically, but I think it's pretty evident from the facts that there was some level of contentious elements to this, and that is probably what resulted in the fine being as high as it is. So anyway, that's my thoughts. And Jen and Julie, I leave it to you so we can at least, give some input about some of the technology.
All right. Yeah, so we do have a couple of slides in here, but in the interest of time, Daniel will not be presenting these, but definitely take a look. We'll make these available, and you can reach out with any questions you have about these. So then we will move on to Jen.
Awesome. Thank you all so much. Really excited to be here today. I'm just going to kind of dive in, following some of the really interesting stories and trends we're seeing in the market to kind of show what Didomi has built from a product perspective and how we can help address some of your needs in the market today. So first, going into the first slide here, we're kind of showing how we can help turn consent, how we can help consent can be turned into, actionable or trusted data. And at Didomi and Sourcepoint, we are, merging together as companies, we built really deep expertise in compliance and privacy. Our teams include industry veterans, with over a decade of experience. We also work very closely with organizations like the IAB, as you can see here, and have in-house experts such as our friend here, Julie, and maintain really strong relationships with regulators as well. So this, combination of experience and collaboration is what really allows us to help businesses move from consent collection to trusted, compliant data activation. So, it really starts with the customer experience, collecting consent through banners, policy, acknowledgements, and preferences. That consent then becomes permission data, classified, verified, and backed by audit trails and compliance checks. And finally, it enables compliant marketing using approved channels, vetted vendors, minimized data, and safe personalization as well. So really the key takeaway is that strong consent preferences, preference and processes don't just protect compliance, they also unlock real business value by enabling safe and effective marketing. So we just have a couple minutes left, so I'll try to go quickly through these slides. I might be condensing my notes on the spot, so bear with me. But this slide is about a realistic compliance evaluation. So with our solution, you don't really need to spend endless time on vendor management or second guessing your setup. Instead, our monitoring simulates how real users interact with your banner, whether they accept, refuse, or take no action at all, and shows you exactly how your site behaves. So these simulations, help uncover hidden cookies and misfiring scripts that could cause non-compliance. So that just means, no surprises later, and just intelligent, reliable validation. So the big benefit is, peace of mind, you stay compliant, avoid risks, and save time while getting more accurate results. Okay, and kind of going through here, this is how we support a seamless consent experience. Throughout the user journey, it starts with anonymous consent when someone has not logged in but still interacts with our digital platforms. Here is the key to ensuring compliance even when the user's identity is unknown. And then we moved into logged in user consent, where users are identified and have accounts on your platforms. In this stage, consent can be synchronized across devices, which really enhances the overall user experience. So using our full suite of solutions, we can help manage consent across the entire life cycle of the user journey. And kind of diving a little deeper, moving farther along, the third stage is user and customer consent. So things like opt-ins for email communications, newsletters, and promotions. This is important because it directly impacts marketing efforts and customer relationships. The fourth stage is data subject access requests. So, giving users the right to access, modify, or release their data. This, really, isn't just a legal obligation. It also helps, build trust with users. So together, these stages show how consent touches both marketing impact and compliance obligations. I am going to see how I can just skip a couple of slides. We have a link for folks to sign up to have a personalized walkthrough demo. And so if you'd like to see any of our features, including like the GPP Global Privacy Protocol, to see how we can help address some of the emerging needs of today, definitely sign up for a demo, and we can walk you through a personalized demo that really speaks to your specific needs and priorities. So I think there's going to be a link for that in the chat. So definitely, if you'd like more information on our product and how we can help you today, definitely sign up for that demo, and we can continue chatting with you then. So I will move to the Q&A slide because I think we're at time, and hand it back over to Julie.
Thank you, Jen. There is one question for you, Jen. Can Didomi turn off tags pixels in the consent management platforms such as meta pixels?
That is a great question. Thank you so much for bringing that up. I will follow up with you to make sure I get you the right information. So yes, we will follow up with you with that answer, if that works.
All right, I think that's all the questions we have. Here is just a quick plug for our next webinar. So if it is something of interest to you, as you can see, we have some pretty great guest speakers on this one. Should be an interesting conversation at the very least. So there's a QR code here for you to scan if you would like to register for your next webinar. Otherwise, thank you so much for attending. As I said, we will make the recording of this available to you via email if you are registered. And we hope to see you again for the next one. Thank you again, Michael and Daniel, for joining, and for Jen for joining at such last minute. I really enjoyed the conversation today.
Thank you so much for having me. Bye, guys.
Thank you. Goodbye.
Bye.